Start. The appellant's appeal under Clause 10 of the latter's patent from the decree of the learned single judge first came for hearing before a my learned brother so and myself stop. During the hearing of the appeal, our attention was drawn to the observation of the learned single judge that a decree for restitution of conjugal rights was granted by consent. Stop. I have a considerable doubt whether this could be done. Stop. On the side, obviously, of the respondent, the contention was that a consent decree of restitution of conjugal rights is not a valid and an enforceable decree. Stop. We did not at that time decide the question whether the decree for restitution of conjugal rights between the parties made on May 18, 1960 was or was not a consent decree, but on April 14, 1967 we referred these two questions to a larger bench. Stop. Can a consent decree for restitution of conjugal rights be passed under Section 9 of Act 25 of 1955, and if passed, is such a decree a valid decree, or is such a decree not a nullity? Question mark. If a consent decree for restitution of conjugal rights is made under Section 9 of Act 25 of 1955, whether it is valid or a nullity or not, if it is not challenged in appeal or by way of other remedy available under the statute and becomes final, can its validity be questioned, or can it be said to be a nullity in proceedings for divorce under Section 13 within bracket 1 within bracket 9 of Act 25 of 1995, since omitted by the Hindu Marriage Amendment Act 1964 within bracket Act 44 of 1964, which inserted Section 13 within bracket 1A in the Act? Question mark. This is how this case has come before the present bench. A further question was raised on the side of the appellant that the decree for restitution of conjugal rights between the present parties is not really a consent decree, and if this is correct, the above two questions obviously would not arise in this particular case. Stop. It is in the wake of this contention on the side of the appellant that the two referring judges and myself were agreeable that the whole case should be heard by this bench, and as also agreed to this course, so we by any order of May 17, 1968 had the whole case laid before us for final decision, which means that not only the two questions referred to the larger bench, but also the petition under Section 13 within bracket 1 within bracket 2 of the Act as such, even on merits, have been before us for final disposal. Stop. So arguments have been heard on all the aspects of the case and not merely confined to the two questions as above. Stop.